Hello and welcome to Narayana Eyes. I'm Pratik, faculty for Polity, IR and Security. Students, we know that yesterday we started with a new theme. The new theme being elections, and I guess we discussed one or two topics under the new theme. Today we'll continue the topics left under the theme elections, and then we can proceed with the last theme, that is miscellaneous section. So we'll try to complete all the topics today itself, but again it's your duty to make sure that you revise each and every topic. Trust me, if you complete all the lectures of polity, current affairs, then trust me, you'll not lose a single mark in the examination, because we have covered each and every important point for the prelims examination. Right, on this note, let us start today's topic, and the name of the topic that we shall be starting with today is delimitation. What exactly is delimitation? So the context being the union government has hinted at conducting a fresh delimitation exercise before the 2029 general elections, right? Though this has sparked debates about its impact on the federal structure. Well, let's leave the context aside. Let's try to understand what exactly is delimitation. Now students, delimitation is the process of redrawing. Redrawing what? The boundaries of the parliamentary the boundaries of parliamentary and parliamentary constituency and the state legislative assembly constituencies. Here we are redrawing the boundaries. Why? Why are we redrawing the boundaries? Because to reflect change in population, because we know that the population changes over a period of time. In order to incorporate the changes in population, the delimitation exercise is held. So the main objective the main objective of delimitation is to ensure equal representation for every citizen. Why? Because this equal representation principle is based on the principle of one vote and one ballot. Delimitation also helps distribute the electoral power. It ensures that the electoral power is distributed fairly, and it prevents any single political party from gaining undue advantage due to the uneven constituency sizes. So we know the constituency sizes, right, is different. Not the population of each and every constituency is not the same. That's the reason the delimitation is this delimitation exercise is held to ensure there is equal representation for every citizen. I hope he understood the main objective of delimitation. Now, this delimitation commission, who conducts the delimitation exercise? It is the delimitation commission. Now, this commission is a high-level independent body. It's an independent body, and who constitutes it? Please remember, this again is a very important point for your prelims. It is the president who constitutes the delimitation commission. So this commission is responsible for carrying the entire delimitation exercise. And this delimitation commission, right, it includes the Supreme Court judge, then the chief election commissioner, and the respective state election commissioners. So one, the Supreme Court judge; the second, the chief election commissioner, and the respective state election commissioners. So these are the points that you need to remember for your examination. Now talking about the delimitation process. Now once the delimitation commission finalizes the number of constituencies and the boundaries of the constituencies, they prepare a draft. It's a draft proposal. Now this draft proposal is kept in the public domain. Why? To receive the feedback from people. The commission holds public sittings to hear the suggestions and objections from the people, and based on this feedback, it may revise, if thinks, it may revise the proposal, and then the final order is then published in the Gazette of India. And let's say, for example, the Delimitation Commission has changed the number and let's say redrawn the constituency boundary of let's say Maharashtra. Then this proposal is also mentioned in Maharashtra State's Gazette, right? And then finally, the change, it comes into effect once the president notifies the proposal. Once the president notifies, the changes as done by the Delimitation Commission comes into effect, comes into force. This is the delimitation process. Now talking about the history of delimitation, now see, now despite having conducted 7 census, we have held so far 7 census in our country, India has undertaken only 4 delimitation exercise. 4 times, 1 in 52, 63, 73 and then 2002. These were the 4 times the delimitation exercise was held. The last delimitation in the year 2002 was based on the 2001 census. Again, each and every point is important for the examination, right? Now, the last delimitation held in the year 2002, it only redrew the boundaries but that did not increase the number of seats. Only they redrew the boundaries to adjust the population or change in population, but they did not increase the number of seats. Why? Because of the 42nd Constitution Amendment Act. Now, this 42nd CA, which was passed in the year 1976, it froze the increase of seats until the 2001 census. This act said that the number of seats won't increase until the 2001 census. This is in the year 1976. So, until 2001 census, there will be no increase in the seats. And then again, 84th CAA was passed in the year 2002, that is post the 2001 census. This again extended the freeze until the census of 2026. So, this one again, this postponed to 2002 and this one is postponing to 2026 and we are nearing the year 2026. And why was this freeze put into place? Because to avoid punishing states that have successfully implemented population control policies, like we have the states of Andhra Pradesh, then we have Telangana, then we have Tamil Nadu, Kerala. That's the reason the freezing of seats was put in place through the 42nd and the 84th Constitutional Amendment Act. Talking of the constitutional provision, Article 82 empowers the Parliament. Who has the power? Parliament to enact delimitation act after every census. So we had 7 census, but we only had 4 delimitation exercise. Article 170 deals with the division of states into territorial constituencies. Division of states into territorial constituencies after every census for the purpose of state legislative assembly elections. And talking of the powers of the Delimitation Commission. Now, the commission's decisions, they are final and they cannot be challenged in court. It is not open to judicial review. So the orders are led before the Parliament and State Legislature. The decision of the Delimitation Commission is led before Parliament and State Legislature, but the Parliament and State Legislature cannot challenge the order passed by the Delimitation Commission. So once the commission takes a decision, it has to be followed and implemented no matter what. I hope you understood the delimitation topic and all the important points under the delimitation topic, right? Let us proceed towards the next topic. The next topic is on the mixed member proportional voting system. Now, India is considering adopting this voting system inspired by New Zealand's successful model. Let us try to understand what exactly is this new voting system. What is the mixed member proportional voting system? Now see, interestingly, this mixed member proportional voting system is a combination of two electoral methods. Combination of two electoral methods. One is the proportional representation that we discussed. This is the voting system that we adopt or we use for the election to the president and vice president. And then we have the traditional constituency based system, where whichever candidates gets the maximum seats, maximum number of votes is declared winner. So here in the MMP system, each voter has two votes. We have one vote. In this system, each voter has two votes. So how does it vote? As I told you, each voter, it gets two votes. Voters can cast two votes. One for the local candidate and another for the political party. So one is for the local candidate, the other one is for the political party. So two votes, one I have to vote for the local candidate, which is a person. The other one, I cannot vote a person, I have to vote a political party. And the local candidates who win, they enter the parliament directly. They enter, like for example, we know the constituencies, right, that we practice in our country. So whoever wins, they enter the parliament directly. While the party list seats, they are adjusted to ensure proportional representation of all the political parties. One, the local candidates who win, they directly enter the parliament. Then we have the party list seats. So party, depending on the votes it gets, they are allotted seats. Who? The political parties. Now, if I talk about the seat allocation in parliament as followed in New Zealand, because we are trying to replicate this practice. One is the electorate MPs, one is the electorate. Who are this? These are the local candidates, which means they are directly elected by winning the highest votes in their local constituencies. So people here are voting local candidates. Then the second one is the list of MPs. Party list MPs, which means once the electorate MPs, these electorate MPs are chosen, the remaining seats are filled. How? By the party's list of candidates. And this system ensures that the total number of seats a party gets matches its share of the party vote. Depending on the votes the party gets, the party is allotted specific number of seats. Now the advantage of this system is that there is flexibility in voting. It allows voters to select a local MP from one political party while voting for a different political party for national representation. Like it happens in Delhi. Until the last year in Delhi, people used to vote Aam Aadmi Party for the local issues, and they used to, in the Lok Sabha elections, they used to vote the BJP political party. So this system, it actually encourages diverse political participation, not the members from one political party. And government formation under the MMP, let's say for example, if no single political party wins an outright majority, then the governments are formed how? Through coalitions. And this system promotes negotiations and power sharing instead of dominance of one political party. And then these are the advantages of enhanced accountability. These points you can read by your own from the notes provided in the description. So I want you to go to the advantages. Once you understand, I hope you understood the MMP system. If not, please let me know or please ask in the comment section. Right? Okay. Let us move on to the next topic, which is the vote from home facility. Now, election commission's home voting facility has been implemented in Delhi and Haryana, right? So let us try to understand what exactly is this vote from home facility. Vote from home facility. Now see, This vote from home, again the name indicates that it's a citizen centric initiative, and who has introduced this? Election Commission. Again a very important point for your examination, right? What is the purpose? The purpose is to enhance that people, each and every category section of people are included. People have the access to vote. People have the access to vote. Now, especially this is very important for people having, let's say, logistic challenge, or let's say mobility challenge. Let's say the people with disabilities. And that's the reason, for the first time in the year 2024, the Election Commission of India, in the history of Lok Sabha elections, this facility, vote from home, was extended to whom? Especially people with disabilities as well as senior citizens aged 85 years and above. So this is a very important point for your examination. Vote from home facility was first introduced, first put into effect, put into function the first time in the year 2024 during Lok Sabha election, and this facility was extended to people with disabilities, and the second one is senior citizens aged 85 years and above. Very important point for your examination. And what is the aim? Purpose of this initiative is to ensure that there's greater voter participation. It allows certain categories of voters to cast their votes without visiting the polling booth station, which means no matter what kind of barrier you have, physical or let's say procedural barrier, this initiative is being, or this initiative takes care of the, let's say, procedural or let's say the physical barriers. Now, eligible categories, again please remember: senior citizens, people with disabilities, media personnel, essential service workers, service voters including armed forces personnel, right? And the procedure, communication, now this one is not that important, but these points that we discussed, they are very important. So, what is the procedure, communication and visit attempts? This you can read in the notes, right? Make sure you are downloading the notes, right? Okay. I hope you understood this vote from home facility. Let us proceed towards the next topic. Electoral bonds. Now, the Supreme Court, it struck down the electoral bond scheme. It said that this is unconstitutional. Fair. Whatever be the context, let us try to understand few basic concepts. First and foremost, what are electoral bonds? Electoral bonds are nothing but they are financial instruments used in India. Why? Why they are used in India? So as to donate money to the political parties. What? To donate money to the political parties. And this idea was first introduced through the Finance Bill of the year 2017. And then the government officially notified the electoral bonds scheme in the year 2018. So this scheme was brought in the year 2018. First, it was introduced through financial bill. Now, what is financial bill? Money bill. Please read the Lakshmikant book. The money bill. In Parliament, there is a section called Money Bill, Financial Bill 1, Financial Bill 2. So, I request you to read the difference. So, the electoral bond scheme was introduced through financial bill in the year 2017, and finally in the year 18, it notified as the electoral bond scheme. The purpose of electoral bond scheme was to replace the cash-based donations. Cash-based donations. Which means we know that, right? People who want to vote or let's say support a political party, they provide cash to the political parties, and we know the amount of black money that gets pumped into the system during the elections. And given that so much black money is used in the elections, the purpose was to replace this cash-based donation so that there can be more transparency in political funding. Henceforth, no more cash. Yes, cash is allowed up to a certain limit, but beyond that you cannot pay the money in cash. So this was the purpose of electoral bonds scheme. I hope you understood the concept of electoral bond scheme. Which means, what is the background now? Which means, let's try to understand the situation before the scheme. Now, before the electoral bond scheme, the political parties had to publicly disclose all the donations exceeding 20,000 rupees. So, all the money it receives exceeding 20,000 rupees, they have to disclose it. And then the corporate donations were restricted or limited to 7.5 percentage. 7.5 percentage of their average net profits over the past 3 financial years. So they cannot, donate as much money they want. No, it's limited to 7.5% of the average net profit of the last 3 financial years. Right. Now, what are the key features of the electoral bond scheme? One is the donor eligibility, which means any individual who is an Indian citizen or any organization that is established in India could purchase electoral bonds. So let's say I want to donate money to political party, then I need to purchase electoral bond. So donor eligibility, who can donate? Any Indian citizen or any organization established in India. Then what about the receiver eligibility? The political parties, only political parties that are registered under the RP Act, Registration of People's Act 1950, and they can receive at least one, and not all the political parties. Political parties who receive 1% of the total votes they got in the last Lok Sabha or let's say the state assembly election, they are allowed to receive the donation via electoral bond. So anyone who secures 1% of the total votes in the last Lok Sabha or the state assembly election. Now what about the authorized bank? Only one bank is allowed, and that is the SBI bank. The SBI was the only bank authorized to issue and encash the electoral bonds. And what was the bond denomination? One, it was 1,000, then 10,000, then 10 lakhs and 1 crore. These were the denominations in which people could purchase the electoral bonds. And validity, talking of the validity, which means these bonds remain valid only for 15 days. 15 days from the date of issuance. And if the bonds were not encashed within this period of 15 days, then the SBI would transfer the unclaimed amount to the Prime Minister's Relief Fund. And limits on the bond value? Yes. There was no upper limit on how many bonds a person or company would or could purchase. However, political parties were still allowed to accept anonymous donation in cash, but only up to 2,000 rupees per donation. So you can accept the money in cash up to 2,000 rupees. Earlier it was 20,000 rupees. Now it was 2,000 rupees. Which means now you need to create more bogus names. This is how the political parties or the funding operates in our country. So some companies, let's say, paying crores and crores of rupees, this amount is divided into small denominations. Ram, Sham, these are the fake names created in order to show that this is the money that we received in cash. So because you do not have to disclose the source of that money, right? So these are the features. I hope you understood the electoral bond scheme and the features under the electoral bond scheme. The next topic that we are going to understand is the Model Code of Conduct. Now, Election Commission of India has enforced the Model Code of Conduct. Okay, so fine. Forget the context. Let us try to understand what exactly is Model Code of Conduct. Model Code of Conduct is nothing but it's the guidelines, right? Set of guidelines, and who issues it? By the Election Commission of India. It's a set of guidelines. Why? It's a guideline to regulate the behavior of the political parties and the candidates in the elections. which means the political parties and the candidates who are contesting in the election should behave responsibly. And this model code of conduct, it ensures, right, that elections are free and they are, without any, let's say, uh, without any issues or let's say problems. The elections are free and there's no interference from any, let's say, foreign country or let's say from the government. The election should be free. That's the reason the Election Commission of India says that people have to behave responsibly. The candidates have to behave responsibly. So see, the MCC, the Model Code of Conduct, is not a law. Please remember, it's not a law. But the Model Code of Conduct, it is backed by moral and let's say the political agreement among the political parties, which means there are certain moral values that each and every political party subscribes to, which means you cannot vote, let's say, you cannot ask votes from the people in the name of religion or caste. This goes against the MCC. And the Model Code of Conduct is enforced through the powers given to the Election Commission of India under Article 324 and the RPI Act of 1951. So, Election Commission of India gets the power from RP Act as well as Article 324 to enforce the Model Code of Conduct. And this Model Code of Conduct is, it comes into force from the day the election schedule is announced by the Election Commission of India. The moment the Election Commission announces, the Model Code of Conduct kicks in. And then it continues until the election results are declared. For the first time, the Model Code of Conduct was implemented in the year 1960 during the Kerala State Assembly election, right? So this is what you need to remember. What are the recent updates, changes done to the MCC? Now see, certain new areas or dimensions were brought under the MCC. Why? To ensure the system is more and more transparent. One is the opinion and exit polls. Opinion, who is going to win the elections? Exit polls, after the votes are cast, who is going to win the election? Which means the opinion polls are banned 48 hours before the polling or let's say voting begins. So 48 hours before the voting begins, the opinion, which means the media channel, cannot publish the opinion poll. And the exit polls can only be published after the voting ends in all the phases of the election, not the first phase or the second phase. After the voting ends in each and every phase, then the media channels are free to publish the exit polls. And this ensures that the voters are not influenced during the, let's say, final stages of the elections or let's say the voting. Then print media advertisement. What are the advertisement? Now, no political advertisements are allowed in newspaper on the polling day or let's say day before the voting. And this helps to avoid last minute, influence on the voters. And what about the government advertisement? Now, the government that is in power can do anything, right, to come back in power. So, on the day of polling, they may announce a new scheme. So, the political leaders and especially the officials of the government cannot appear in the official advertisement during the entire election period. Why? To prevent the misuse of public resources. So, if you see, overall, the Model Code of Conduct, it serves as a very important tool to maintain the integrity of the election process and ensure that there's level playing field for all the political parties in our country, so that no political party, no matter how big or small, is influenced because of the size of the political party. So there's level playing field no matter how big or small you are. The Election Commission of India ensures that you are getting equal opportunity, equal chance to, let's say, contest in the elections and have a chance of winning the election. So this is the Model Code of Conduct. So again, these are the important rules I I want you to go through the rules for party in power regarding schemes. So again, you can download the notes and quickly go through the rules under the MCC. Next, what is one nation, one election? So the high level committee headed by former president submitted a detailed report on one nation, one election to the President of India. So let us try to understand what exactly is one nation, one election. Okay, so one nation, one election, the name itself indicates what? So the idea, one nation, it refers to the idea of conducting elections to the Lok Sabha, all the state legislative assemblies, and also both the urban and local bodies, that is panchayats and the municipalities at the same time. Now we know the Lok Sabha election, the state elections, the local elections happen at different intervals, different time. Now the purpose is to have elections for all these three bodies or at three levels at the same time. See, between 1951 to 1967, the elections to the Lok Sabha and all the state assemblies, not the local bodies. Why? Because the local bodies came into the year 1994. So election to the states and the Lok Sabha was held together until 1967. Why? Because the Congress political party was dominating. Now we had, or the country saw different political parties coming, and this cycle of, having elections simultaneous, it broke. Why? Due to the earlier dissolutions of, let's say, some state governments. So the idea of bringing back simultaneous, or let's say coterminous elections was first proposed by the Election Commission of India. So Election Commission first proposed in the year 1983. Then the Law Commission also supported this proposal in the year 1999. And then again in the 2014 Lok Sabha election, the BJP political party mooted the idea of simultaneous elections, which means it mentioned in the manifesto of the BJP. Now, which are the recommendations given by the high level committee? One, so this high level committee recommended the simultaneous elections in our country. They want that simultaneous election should happen in our country. So first is, they said that we need to amend the constitution, which means it said that we have to address, or we have to, in order to ensure that we have simultaneous elections, we have to amend the constitution. So in the first phase, the Lok Sabha and the state assembly election could be synchronized. In the first phase, you cannot synchronize the local elections. In the first phase, please make sure that you are synchronizing Lok Sabha and the state assembly elections, and then in the second phase, the local body elections would be aligned with the Lok Sabha and the state legislative assembly. So first phase, Lok Sabha and the state assembly. Second phase, the local body with the Lok Sabha and the state assembly. What about the ratification requirement? See, the first phase where you need to sync or get in sync the Lok Sabha and the state assembly election does not require the approval from the states. But in the second phase, when you plan to align the local body elections, you need the approval from 50% of the states. So of all the states we have in our country, ratification approval of 50% of states is required. Why? Because this is actually affecting the federal power. The next, unified electoral roll and voter ID, which means the committee proposed that there should be a single electoral roll, single electoral roll and voter ID. And this will be managed by the Election Commission of India, of course, in coordination with the State Election Commission. And also, this also requires approval of half of the states. And then, what if the if no political party secures majority? This is referred to as hung assembly. Now, in this case, the recommendation is to conduct fresh elections only for the remainder of the term and not for full 5 years. So, let's say for example, if the in the course of 5 years, if a government dissolves, loses majority, then fresh elections should be conducted, but the tenure of the new government should only be for the remainder of the time and not for the full 5 years. These are the recommendations. I hope you understood the recommendation of the high level committee. Let us proceed with the next topic, that is allocation of symbols to political parties. Let's give the context. Let's hit or understand the main dimensions in the article. So, what are registered unrecognized political parties? Now, this is something that we already discussed yesterday. So, again, anyone who has revised will be in a position to answer. Which means the recognized unregulated political parties include newly registered political parties. Which means these political parties haven't contested elections since the registration. And also those political parties that fail to meet the required vote share to be recognized as either the national or state political party, which means they have not met the criteria to be recognized as the national or let's say state political party. But they are officially registered. They do not receive full benefits as provided to the state or let's say the national political parties. Now see, the registered unrecognized political parties are political parties registered with the Election Commission under Article 324. They must apply within 30 days of their formation. So, even if you let's say haven't contested the election, you can still register your political parties with the Election Commission of India. The question is, how are the symbols allotted to the political parties? Now, please remember that the Election Symbols Reservation and Allotment Order 1968 governs how the symbols are allocated. Who governs it? The Election Commission of India. So it divides the symbols into two types. One is the reserved symbols and free symbol. Now this part can be asked in the examination. This part can be asked in the prelims examination. Now talking of the reserved symbols. Now these symbols are given to recognize national or the state political parties like BJP, Aam Aadmi Party. And in case there is a split in the recognized political party, as happened with the Shiv Sena, which is a state political party in Maharashtra, then it is the Election Commission of India who decides which faction of the two factions or three factions will keep the original symbol of the political party. They of course consider all the facts as support, they hear both the sides. Now, decision of the Election Commission of India in regard with allocation of symbol in case of split is final and binding. It cannot be simply challenged. And if there is a split in a registered but unrecognized political party, then the Election Commission of India usually suggests that the factions resolve the matter internally or let's say through the court. So this reserved symbol is for the national or state political party. Free symbols, talking on the free symbols, they are allotted to the registered unrecognized political party based on their let's say the application and commitment. And what is the commitment? That they will contest, field at least 5% of the total candidates in the upcoming state assembly election. And then to receive a common symbol in future elections, common symbol. The registered unrecognized political parties must have secured at least 1% of the vote in the previous state or national, that is Lok Sabha elections. Then the party must notify the Election Commission of India of its preferred symbol. When there is a common symbol, they will then notify the Election Commission of India that this is a symbol that we are preferring. They have to inform this at least 6 months before the notification of the Election Commission of India. So this one is for the registered unrecognized political parties. Reserved symbol is for the recognized state or national political parties. Now, which is a recent amendment? So this is something that we already discussed yesterday. So again, I want you to please go through the notes to understand the recent amendment. Now, this question has been asked in the examination. Criteria for national political party. So, which are the criteria on the basis of which the Election Commission of India declares a political party to be a national political party or a state political party? These are the criteria. So again, this is very factual. For national political party as well as a state political party, I want you to read it by your own. It's self-explanatory. So please read by your own and remember it. Why? Because this is very important. UPSC has asked questions as the reason. Make sure that you remember the criteria for national as well as a state political party. Let's proceed towards the next topic, which talks about nota, that is none of the above in the Indian elections. The first and foremost is, what is nota? Nota, which means none of the above, is a voting option that allows voters to reject all candidates contesting in a particular election. Now, if citizens, or rather it empowers citizens a choice to vote but still express disapproval, which means they do not like any candidates contesting in a particular constituency. Now, this actually, it helps a voter to show that he is not happy with the candidates the political parties have, let's say, given the ticket to. Now, nota for the first time was introduced in the 2013 assembly elections in the 5 states and was used in the 2014 general elections afterwards. So this is a point that you need to remember for your examination. And what are the key features of nota? Now, see, it helps voters reject all the candidates while keeping their choice, secret. So the votes cast for nota are counted but treated as invalid, which means they do not affect the result, which means even if the nota gets the highest votes, the candidate with the next highest votes is declared winner. Judicial intervention. Now, in the 2013, PUCL versus Union of India case, the Supreme Court directed the Election Commission to introduce nota, giving citizens the right to reject all the candidates. That's the reason in the 14 Lok Sabha election, it was used for the first time. And what about the implications of nota? It's positive as well as negative. What is the positive implication? Now, nota, it strengthens the voter empowerment. How? It offers a choice to reject all the candidates, right? And this actually supports the democratic principle of, let's say, democratic principle of choice. Now, a large number of nota votes also sends a very strong message of discontent to the political parties, indicating that people are not satisfied with the candidates the political parties have given the ticket to. And what is the negative implication? It does not affect the outcome of the election. Why? Because it is treated as invalid vote. Now, this can actually frustrate the voter who want their, dissent, disapproval to have some real consequence. And as there is no direct outcome for parties or, let's say, candidates, even when nota gets many votes, it overall influences, or it overall influence stays limited, which means the influence of the nota, it stays very limited. So this is the negative implication, which means despite having the vote, there is no outcome as such. There is no consequence. Your vote will be considered invalid. So this is the negative implication. And then let's move on to the last topic under the theme elections. Twin candidature in elections. Now, in the 2024 Lok Sabha elections, Rahul Gandhi contested from 2 constituencies and one from both the constituencies, that is Raebareli and Wayanad in Kerala. He later decided to retain the Raebareli seat and he vacated the Wayanad seat. So what exactly is this twin candidature? Let us try to understand. If I talk about the twin candidature, which means one person can contest from two constituencies. There is a legal provision under section 33 clause 7 of the RP Act. A candidate is allowed to contest elections from up to two constituencies. Two constituencies. Now earlier, that is before the 1996, before the 1996 amendment, there was no limit on the number of seats a candidate could contest, which means a candidate could also contest from 3 or more seats. However, this was later changed to restrict to a maximum of 2. Now, if a candidate wins from both the seats, as it happened with Rahul Gandhi, they must vacate one of them within 14 days. Within 14 days, the candidate has to mention that this is the seat that I am going to vacate. Else, if he does not intimate, it automatically leads to by-election in the vacated seats, which means once he vacates a seat, then by-election is held for that vacated seat, which means election in that constituency is again held. Now, there have been many such examples. For example, in the year 1996, Atal Bihari Vajpayee contested from Lucknow as well as Gandhinagar and won from both the seats, but he retained Lucknow. Then in the year again 1999, Sonia Gandhi contested from Raebareli and Amethi. Narendra Modi also in the year 2014 contested from Vadodara and Varanasi and he retained Varanasi. And then we have the example of Rahul Gandhi. So now given that candidate can contest from two seats and then one they have to vacate, which means election has to be held again. In this slide, the Election Commission of India has recommended that the law should be amended to allow candidates to contest from only one constituency. Why? Because of the by-election to be, again, we need to let's say, contest an election, hold an election. And this now holding by-election, which means again, the Election Commission of India has to spend money. Whose money is it? It's for people money. And that's the reason the commission, propose that if a candidate wins from both the seats, they should bear the financial cost of the, let's say, by-election. It also suggested, I guess, let's say 5 lakh rupees for the state assembly election and 10 lakh rupees for the Lok Sabha election. So this is the topic. And this brings us to the end of the final topic under the theme elections. So I hope you understood all the topics that we have covered, right, in the theme elections. Now in the next section, we'll continue this lecture. In the next session. We'll ensure or we'll start with a new theme. The new theme being miscellaneous. So this session ends over here, right? In some time, we'll start with a new session on a new theme, that is miscellaneous, right? So we are left with the last theme, that is miscellaneous section, right? So there are close to 14 topics, 15 topics under the new theme, but in this theme, I expect you to read few topics by your own. As we have covered all the topics under all the themes except for this one, I hope you're in a position to understand the topics by your own now. Now, these topics are not that complicated or let's say difficult as compared to the topics that we have seen before, and that's the reason I expect you to read few of the topics by your own. I hope you will, right? So these are the topics that we shall be discussing. Quickly go through the topics. So 1 and then 15 topics. Let us start with the first topic. And before we start, again, there's an announcement. Narayana IS is soon going to launch 1 year and 2 year Prelims and Mains integrated program. All those students who are serious about the examination, wants to clear the examination, contribute to the growth of a nation, please scan the QR code available on the screen and our team will get back to you. Right, make sure that you are mentioning or you're calling on the given numbers in case you have any doubt, right? Make sure that you are availing this benefit that we are launching soon, so that you dream of achieving something big in your life, and thus you contribute to the growth of our nation, right? So let us start with the first topic, and the topic is Universal Declaration of Human Rights. What is the context? The year 2023 marks the 75th anniversary of Universal Declaration of Human Rights. So question can be asked on sort of this topic. So Universal Declaration of Human Rights. See, the United Nations Human Declaration was adopted by the UNGA, that is United Nations General Assembly, on 10th December 1948. See, this declaration is considered a foundational document that outlines the basic rights and freedoms that belong to every human being. Doesn't matter which race, which gender, which nationality, which religion, which caste he or she belongs to. There are basic rights which each and every human being should enjoy. So the Universal Declaration of Human Rights, it includes a wide range of essential rights. Which are these rights? Right to life and liberty, freedom from slavery and torture, freedom of opinion and expression, education, right to work with fair condition. And then Nelson Mandela, he highlighted that denying people these basic rights, these basic human rights, is an attack on their humanity and dignity. Now, talking about the legal status of Universal Declaration of Human Rights, right? Now, the Universal Declaration of Human Rights is not legally binding, but it has inspired many national as well as international treaties, and over time, it has been widely accepted as a global standard for human rights. So, whenever any country is framing a policy, or let's say a law on human rights, this is a document that each and every country refers to, or let's say the international treaties refer to. Formation of International Bill of Human Rights. Now, this declaration, along with the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights, forms what is known as the International Bill of Human Rights. The Vienna Declaration and the Program of Action adopted in 1993, it reinforced, strengthened the importance of the declaration. And talking about India, now India actively participated in drafting the declaration and was one of the original founding members and voted in favor of the establishment of the Universal Declaration on Human Rights. To respect the declaration, the Indian Constitution, especially the chapter on fundamental rights, Article 12 to Article 35, reflects the principle of the Universal Declaration. Why? Because it guarantees equality, freedom, protection from exploitation, religious liberty, and most importantly, educational rights, especially for the minorities. So, this is the first topic on Universal Declaration of Human Rights. The next topic talks about the inheritance tax rebate. And our senior leader from Congress political party supported the idea of bringing back inheritance tax. Right? So let us try to understand what exactly is inheritance tax. Now see, the inheritance tax is a levy on assets or property that a person receives after the death of another person. So we know inheritance, right? The property of a father is passed down to his son, or let's say daughter. This is what is inheritance. Now the inheritance can be received either through a, let's say, legal will, or let's say under the personal laws of different religions. The tax is calculated on the value of the inherited assets and is paid by the beneficiary who receives them to the government. So let's say I'm inheriting properties from my father. Now the government is imposing tax on the value of the property I have inherited from my, father. So this is what one understands by inheritance tax. Now, in some countries, inheritance tax can be as high as 55%, which means, let's say, if I'm inheriting the property worth 100 crores, 55% is something that I need to give it to the government. The question is, did India ever have an inheritance tax? Yes, India had. So India had a form of inheritance tax earlier, which was known as the estate duty. What? Estate duty. Now, this was introduced for the first time in the year 1953. Now, this tax is applied to the principal value of the estate that exceeded 1 lakh, and then I guess it also followed, yes, it followed the progressive tax rate ranging from 5% to 40% for the properties valued over 20 lakh. So, if the property value is more, the tax rate will be more. But this, estate duty was abolished in the year 1985 by the Rajiv Gandhi government. At present, India does not levy any tax on any inherited property. So, this is something that you need to remember for your prelims examination. India has no inheritance tax, but India had inheritance tax in the past. So, this type of questions can again be asked in the examination. These are the countries that have or that levy inheritance tax on the people of their country. Next, what exactly is this egg shell skull rule? Now, a simple question can be asked. The eggshell skull rule refers to which of the following 4 options? So, let's try to understand what exactly is this. The Supreme Court recently restored the 5 lakh compensation that had originally been awarded by the District Consumer Forum in a case of medical negligence. Forget the context, let us focus on the case background, the meaning of the rule and an example. Now, what was the case background? See, this case actually involved Jyoti Devi. This lady, she underwent a operation to remove, I think, appendix, but she continued experiencing pain due to, let's say, something which was present in her body which the doctors failed to remove it, and this was causing a lot of pain. And then she complained. Then the District Consumer Forum awarded 5 lakh compensation, but this amount was reduced. This amount was reduced by the State Forum and later only partially restored by the National Consumer Forum. Which means the District Forum awarded 5 lakh compensation, the State Forum reduced this amount, the National Forum partially restored the amount which the State Forum had reduced. Forget. So there's medical negligence, so the District Forum awarded 5 lakh compensation, which the Supreme Court also upheld. Now, what is this eggshell skull rule? Now, see. Now, this rule says that a defendant is fully responsible for all the injuries caused to a victim. Defendant, who is defendant? The doctor. Even if the harm is more serious than expected due to the victim's pre-existing medical condition. Which means, let's say a patient has a pre-existing medical condition. Even if this is the case and if the doctor causes any harm to the patient, then the doctor is fully liable to pay the compensation. Which essentially means that if a person suffers worse consequences than like most people would, the person responsible is still liable for the full damage. In this case, the doctor or the hospital. So it applies not only to the physical harm but also to the emotional and psychological harm. This is what one understands by the term eggshell skull rule. Now you may wonder, why has this name been given? So there's a very interesting story. Now see, the name of the rule comes from a, let's say, hypothetical example. If someone has a skull as delicate as, let's say, an eggshell and gets hit on the head, causing severe injury, the person who caused the harm cannot escape liability just because the victim was fragile. So, doesn't matter in which condition the victim is, no matter which medical conditions he or she has, if the doctor causes any damage to the patient, to the victim, the doctor or let's say the hospital is fully liable to pay compensation to the victim. This is what we understand by the term eggshell skull rule. I hope you understood the term. So again, I hope you understood the term. So question can be asked, so you should be prepared. Let's proceed towards the next topic. EFIR E, that is Electronic First Information Report under the newly constituted BNSS 2023. That is, this law replaced the Criminal Procedure Code. Now, EFIR is the electronic or digital version of FIR, which means it allows a person to report certain types of offenses online. One thing that you need to remember, that not all the offenses can be filed digitally. One important point. So this replaces CRPC. It includes provision for registering FIRs electronically under section this. As per the law, cognizable offences which are not that serious. We discussed the difference between cognizable and non-cognizable. The cognizable offence are bailable. So cognizable offence is reported through electronic communication, right? And the informant must sign the report within 3 days to ensure its validity and formal acceptance. So it is only applicable for cognizable offence. So this is the point that you need to remember. Important point for your prelims examination. Applicability permitted only for certain cognizable offences such as theft, burglary, motor vehicle theft and similar property related crimes. Non-cognizable offence like defamation, cheating, they cannot be reported through EFIR, which means to report a non-cognizable offence, a person has to it's mandatory for the person to come to the police station to file non-cognizable offence. So this is the point that you need to remember for your prelims examination. Now what are the advantages? Now one advantage is that the EFI, it enhances the accessibility by allowing people to, let's say, report crimes without physically being present at the police station. And this is very helpful for individuals who are living in the remote areas or who cannot travel easily. And then this digital format also improves efficiency in the, let's say, the processing complaints and brings greater transparency, right? And there are some limitations as well. And what is the limitation? See, the scope of EFIR is limited only to certain cognizable offences and cannot be used for all categories, which means additionally the requirement of the informant's signature within 3 days. Once he reports the complaint or incident online, he has to come within 3 days to sign. This actually also is introducing a procedural hurdle, which means they have to wait for 3 days. And this can also lead to delay in solving the case. So this is a limitation. I hope you understood the topic. So few points that I emphasize, they are important for the examination. Next is the foreigners tribunals in India, role, function and amendments. Now, the foreigners tribunal, they are quasi-judicial. We have understood the meaning of quasi-judicial. So most of the points, concepts we already have discussed, so I am not going to repeat the same. They are quasi-judicial bodies. They are constituted under the Foreigners Tribunals Order 1964, and this order was framed under Section 3 of the Foreigners Act of 1946. Which means the foreigners tribunals, they are responsible for determining whether a person is a foreigner, that is not a citizen of India, especially in states like Assam where the question of NRC or where the issue of NRC has met with a lot of protest, criticism. So whether a person is a citizen or foreigner is something that the foreigners tribunal will decide. Now, given that the NRC was implemented in the state of Assam, there have been many people who were declared foreigners. So, to give a chance to those people to prove their Indian citizen, we have the foreigners tribunal. So, these tribunals are empowered to deliver opinions on, let's say, the nationality status, whether someone is an Indian citizen or foreigner. And then when it comes to the functions and authority, the central government has the power to constitute or establish such tribunals. and they also have the civil court powers of a civil court, which means again it's a quasi judicial body, right? So this is the foreigners tribunal. So please remember the act, right? It's a quasi judicial body. Next, amendment to the Foreigners Tribunal Order 19. Now this amendment was made to facilitate appeals post NRC exclusion. As I told you, in the year 19 the NRC exercise was completed. So people who did not find their name in the NRC, in order to give them a chance so that they could appeal to prove their citizenship, we established, India, the central government established tribunal. Now this purpose applicability is not that very important. Now empowering individuals, which means they can approach the tribunals directly, right? So this is something that you can read by your own, not that very important for the examination, but still have a quickly glance or have a glance over these points. Next topic. India's under trial prisoners. The question is, who are the under trial prisoners? Now, again, we have discussed this topic, so I would expect you to, understand by your. But still, quickly, let's try to understand who are the under trial prisoners. Now, the under trial people are those individuals who are held in custody, the police custody, or let's say the jail, so to say, or judicial custody during the course of the trial. Which means, let's say a person has been accused of murder. It is yet to be proved in a court. Until the time the court proves whether he is guilty or not guilty, a person unfortunately has to spend a lot of time in the jail. Such people are referred to as under trial. Now, there have been people who have spent more time, that is, more time than the punishment prescribed for that crime. So the punishment, let's say, is 3 years in jail. People have spent more than 3 years. Why? Because in India, getting justice, solving cases takes years and years. And this prolonged detention of such people, these people are poor. They do not have lawyers. They cannot hire lawyers. So they have to unfortunately spend time behind the bars. And this actually affects their fundamental rights, especially under Article 21 and Article 14 of the Indian Constitution. 21 says right to life and personal liberty. Talking about the legal and the constitutional provision, now matters related to prison, they fall in the state list. State list which falls under the 7th schedule of the Indian Constitution. And then the Modern Prison Act 2023. This Act 2023, which is framed in the year 2023, provides a reformative framework. It aims to improve the treatment of under trials and modernize the prison administration, which essentially means that punishment, that is spending time in jail, working in the jail, is not the only way to punish. Reformative, which means a person can be subjected to do community work so that he sort of instills the responsibility of the community, and this helps a person to become more mature, and then he can be brought back into the mainstream society. Regarding the statutory safeguards under the newly constituted BNSS, now section 497, which replaced the CRPC Act, it mandates, or this newly constituted section, it mandates release of the under trial if the under trial has spent half of the maximum sentence as an under trial and is not charged with offenses punishable by death or life imprisonment. Which means, let's say for example, a person has, uh, let's say a person is accused of robbery and the punishment for which is 5 years, and if the person has spent more than, let's say, 2.5 years in the jail, then this section mandates that this person has to be set free. Why? Because the trial is taking a lot of time, and it is the let's say a responsibility of the state to ensure that the trial happens as quick as possible, and as the state is responsible, so this section says that a person who has spent more than half of the time in jail should be released. It also allows for the release of first time offenders, people who have committed, let's say, a mistake crime for the first time and have spent more than one third of the maximum sentence awarded for that or against that crime. So I hope you understood who are under trial, prisoners, the statutory safeguard. This one is important, can be asked in the examination. The judicial intervention, role of National Human Rights Commission, we already have discussed. So I want you to please read by your own. Now this is the status of under trial prisoners. So these points are important for you to remember. So close to 75% of the total prisoners are under trials. The total prisoners are like 5,73,000, of which 76% people are under trials, which means they are spending time in jail without the trial being concluded. Increase in under trials since 2017, 40% there has been increase since 2017. I am talking the demographic disparities among the under trial prisoners. SC constitute 20%, ST 6.5, Muslims higher than their population share of 14.2%. This is alarming. So there's something wrong in the society, the education. The government has to think and ensure that this problem should be stemmed. Let us move on to the next topic. The cantonment boards and the recent land transfer reform. So, the government has initiated the process of transferring nearly 20,000 acres of land from 10 cantonment boards across 5 states to local state bodies like the panchayats and municipalities. This land includes private properties and municipal facilities, aiming to modernize the governance structures and reduce the administrative responsibilities of the armed forces. First and foremost, what exactly is cantonment board? Now, this is something that you must have studied in the under the 74th Constitutional Amendment Act, isn't it? So, what is a cantonment board? It is nothing but it's a civic administration body. Civic It's a civic administration body. It was established under the Cantonment Act of the year 2006. Cantonment Act of So this act led to the establishment of the Cantonment Board. Now these boards are under the Ministry of Defence. They are under the Ministry of MOD. Cantonment Board, they fall under the Ministry of Defence, and they also comprise representatives from the armed forces, then the Director General Defence Estate, the state officials, the elected members. So cantonment board has members, let's say, from the armed forces, then from the state officials, from the local bodies, the elected members. So these points are important for the examination. This Act of 2006, it's a civic administration body, comprises members of the armed forces and the elected members as well. The constitutional and legal basis. The governance, who will govern the cantonment? And let's say the housing, it falls within the union list. It falls within the union list under the 7th schedule. So when it comes to cantonment board, it falls under the union list. As of now, there are 61 cantonment board existing and initially notified under the Cantonment Act of 1924. Later on, this act was replaced by the 2006. So as of now, there are 61 cantonment board existing. Categories of cantonments. These are categorized into 4 types based on the population size of the cantonment area. They serve as green zones, combining environmental conservation with civic responsibilities despite facing limitations. Right? Now, what is this land ownership and control? What exactly is this issue? See, the land with the cantonment is owned either by the armed forces or the central government. One important point for examination. It is either owned by the armed forces or the central government. Even the leased land held by the private individuals, right, they remain under the control of the central government. Even the property belongs to a private person but is leased, still the control is under the central government. And what is the purpose of the ongoing reform where the government has transferred the land, let's say, to the local bodies? See, the purpose of the reform is to, let's say, shift governance responsibilities to the state level local bodies. This actually falls in the line of, let's say, modern municipal governance system. It ensures that, or you see here that the responsibility, one experiences that the responsibility of the military is being reduced. Why? Because the cantonment board, right? The armed forces are involved. Now, armed forces, is it the duty of the armed forces to look after the governance? No. This is the, let's say, policy that the Britishers had, devised. But now we are actually moving out of the colonial fold. As a reason, we are shifting the responsibility to the local bodies. Now, which are the cantonment which are affected? This you can read by your own. Now, of the 61 cantonment, only 6 were created after independence. So, this point is again important for you to see. What is the question? What is the difference between cantonment and military station? You may often wonder what exactly is the difference. See, the cantonments are home to both military as well as civilian population. You must have seen many cantonment boards. It's home to both military and the civilian populations. They are governed by the Cantonment Act of 2006, which we have discussed. Talking about the military station, now military stations, they are purely from armed forces and there are no civilians residing inside the military station. They are not, military stations are not governed by the Cantonment Board Act. So this is the difference that you need to remember. And then the Director General Defense Estate. Now he is an inter-services organization under the Ministry of Defense, responsible for overseeing the cantonment administration. So who is the Director General Defense Estate, and which are the functions or responsibilities? So these are some of the functions of the Director General Defense Estate. So please read by your own. This is self-explanatory. Let us move on to the next topic. Diplomatic passport eligibility, privileges and recent developments, right? Now, a diplomatic passport, what exactly? Let's forget the context. Let's only start understanding the concept behind the topics that we'll be discussing. A diplomatic passport is a maroon colored. This is important for your examination. It's a maroon colored travel document issued. Who issues? Government of India for official international travel. So let's say tomorrow you become IS officer and you're representing India, let's say in the United Nations. So maroon colored passport will be issued to you by the government of India. It is valid up to 5 years and grants special privileges. For example, you cannot be arrested, you cannot be detained, and there are certain legal proceedings in the host country. In contrast, the ordinary passport that the common people have, it's blue in color and valid for 10 years, right? So question is, what is the difference between passport and visa? At times students may get confused between the difference between passport and visa. See, passport is a document which is issued by the government that certifies the identity and nationality of, let's say, the holder of a passport for international travel. So I want to go, let's say, to a foreign country, I need a passport. So passport, who issues it? My country's government. Now, visa is nothing but it is an authorization from a foreign country. I want to go to the United States. So, visa is something that America will issue me. Passport, my country, Indian government will issue me the passport, and visa will be issued from the country I intend to travel. So, the purpose of visa, which means the other countries allowing me to enter their country, stay there for some specific period. This is the difference between visa and passport. Now, who issues passport, diplomatic passport? Again, I want you to read by your own. This is self-explanatory. Who revokes, cancels the diplomatic passport? What are the visa exemptions and political clearance? For example, the Indian diplomatic passport, the Indian Foreign Service officers, example, they enjoy visa-free travel to countries, which means they do not require visa from countries like Germany and 34 countries. So there are 35 countries, let's say if the diplomatic passport holders, they do not require visa, they can simply travel to the country. Now this is the ordinary passport that the common people have, the official passport, white colored, the immigration check post, the e-passport, the Tatkal passport. So these are some things that you can read what is it about eligibility criteria, validity, right? So official passport, the government officials on official duty. So if you are going on a, let's say, government work, then this official passport which is white in color will be issued to you. Right? So this is something that I want you to read by your. Let us move on to the next topic. The Khap Panchayat system in India. Now, what is Khap Panchayat? See, the Khap Panchayat, they are the traditional societal institutions. They function as informal local councils or local courts in the rural part of the country. Now, they are very, very dominant in states like Uttar Pradesh, Rajasthan, Haryana, right? And if you see that they have their origins in centuries old community structures. The purpose of community or Kha Panchayat is to resolve internal dispute and maintain social order. Let's say within a specific clan group or caste group. So they work as informal, let's say, group. If there are any issues within a clan, within a caste, so Kha Panchayats are responsible to to resolve the dispute. Kha Panchayat, it consists of the elderly people of that community. And what is the function? The function being they serve as conflict resolution mechanism. Now they are seen as collective of village, let's say elders. They offer mediation and solutions based on customary practices, or let's say the community traditions and practices which have been going on for years. Now this Kha Panchayat system was existing before independence, when the formal legal mechanism was absent, when there were no courts, no laws. So such type of system was existing to regulate the people of their community or clan. But in recent times, the controversy being that in recent time the Kha Panchayats have, let's say, drawn national attention, criticism. Why? Because of the way they have been enforcing some very old, very regressive social practices. For example, they oppose the, when two people from different castes are married, intercaste marriages, the same gotra marriages is something that they oppose. So again, the constitution allows people to marry, doesn't matter which religion or caste he or she is from. So which means they're actually operating outside the constitution and legal framework. And the decisions that they take, it is not, or the law does not support the decisions that these people take. That's the reason few of their actions have actually led to human rights concern. For example, we have seen that the Kha Panchayats, the elderly people, the people of Kha Panchayats have killed people. Why? In the name of honor killing. For people who marry outside their caste or same gotra, different religion, these people have went on to kill the people who have actually defamed, as per their understanding, defamed their village or community. And these practices actually have raised serious questions about the gender justice, personal liberty, and most importantly, the rule of law, which is defined in the Indian Constitution. So this is what we understand by the Kha Panchayat system. So if you see the difference, so please do not confuse the Kha Panchayat with the village panchayats. The village panchayat are the constitutionally recognized bodies. These are extra constitutional. The Kha Panchayat, they are not backed by any law or any constitutional provision or mandate. So again, this is something that you can read by your own. Next, what is unified pension scheme? Now, the unified pension scheme was approved by the government recently, right? So, it has been introduced to strike a balance between financial sustainability and pension assurance. Now, see, first you need to understand what is OPS and NPS, the old pension system and the new pension system. Now, the old pension system, it provided a, let's say, guaranteed fixed pension to the government employees who joined the government before 2004. OPS to the government employees who joined before 2004, and these government employees get guaranteed fixed pension from the government, and this pension is funded entirely by the government. But in 2004, the BJP, the NDA government replaced the OPS with the national pension system. The NPS, it actually follows a contributory model where both the employee as well as the government contribute to a pension, let's say pension corpus. Here in the OPS, the entire contribution is made by the government. Let's say government is contributing 30, let's say 10,000. So the pension amount is 10,000. So this amount is contributed entirely by the government in the OPS. In the NPS, the government contributes 5,000, you contribute 5,000. This is how the system works. Now, because of the OPS, right, the government was under tremendous financial strain. The government bought loans and it was not a financially sustainable model. So this system had to be replaced with the national pension system and the unified pension system. Now this actually gives you guaranteed pension. This, it also ensures financial wisdom. So this unified payment system, it actually borrows the features from OPS as well as the NPS. Now, the Unified Pension Scheme is based on the recommendations of the TV Somanathan Committee. Again, a very important point for your prelims. Somanathan Committee with respect to UPS, please remember. So, this UPS, it integrates the stability of the OPS. This is what we discussed with the funded and contributory feature of the NPS. Contributory feature. The aim is to ensure assured pension while maintaining fiscal discipline, which means the government should not be under tremendous financial burden. Now, which are the key features of the UPS? Again, you can once you understood the concept, you can read by your own. So, assured like the OPS, UPS guarantees a pension amounting to 50% of the employee's average basic pay over the last 12 months before retirement. Assured minimum pension for those retiring after at least 10 years of service. There is an assured minimum pension of rupees 10,000. Family pension, inflation indexation, which means it also takes into account inflation, and then lump sum payment after retirement. Superannuation is after retirement. So these are some features you can read by your own. And eligibility, who are eligibility, applicability, adoption by states, again very, you can simply read by your own. Again, there's nothing much to explain. Now next is the APAR ID system. What is APAR stands for? The Automated Permanent Academic Account Registry is newly introduced digital identity initiative for students in India. In response to its rollout, several state governments have asked schools to obtain parental consent for the creation of APAR IDs. This initiative aligns with One Nation, One Student ID. Again, can be asked in the examination. The APAR ID system. So what is the objective of APAR ID? Which means everyone will have one APAR ID, every student. The aim is to provide each student with a unique lifelong identification number like we have the Aadhaar number. And this actually allows students to track the academic progress from pre-primary education to higher education. So this covers pre-primary to higher, again an important point for your prelims examination. So each and every record will be stored in the digital medium. There will be a digital record of a student's entire academic journey. This is what APAR stands for. Implementation, the Ministry of Education is responsible, right? Voluntary nature, which means it is not mandatory, which means the registration, if a student wants to register, it is completely voluntary and not mandatory for the students. And then schools are also required to obtain, consent from the parents before generating the ID for that particular student. And do you think there are benefits of this scheme? Of course. It allows the government to actually collect and analyze key indicators such as literacy levels, dropout rates, learning outcomes, so that this helps government to frame the policies in a better and effective manner. Then talking about data authenticity. Now, only first party issuers such as the examinations boards, the educational institutions can upload the credits of a particular student in his, let's say, system. And this actually ensures the credibility of records. So these are the benefits of the APAR ID. I hope you have understood APAR ID. So what exactly is this ID, whether it's mandatory, voluntary, ministry, these are the important points for you to remember for the examination. Let us move on to the next topic. We already have covered right to information. Here the government says that we are excluding this institution from the RTA, which means people of a country cannot ask information about this computer emergency response team. This is the essence or context. We know that the right to information, this was a law that was framed in the year 2005, actually empower the citizens of our country to get the information. From whom? From the public officials. And then we also have discussed the Supreme Court case, where the Supreme Court said that right to information is a part of Article 19 of the Indian Constitution. It makes or it links this right to information with the fundamental right. Right? So I hope you understand what is RTM. Now section 24, exemption of security and intelligence agencies. We already have discussed the fact that the security agencies, for example, you cannot ask the information, let's say from the IB intelligence bureau, let's say from the armed forces, let's say from the research and analysis wing. You cannot ask the information. Why? Because anything that is connected to national security, sovereignty of a country, you cannot seek the information from the government. In this context, you need to understand. So these are the exemptions we already have discussed under right to information. Now we'll understand about the certain. Certain, that is Computer Emergency Response Team, is the national nodal agency responsible for handling cyber security incidents across the country. It was established in the year 2004 under the Section 70B of IT Act of 2000. Falls under Ministry of Information. Again, very, very important. What is the function? Prevent cyber attacks. All you need to remember is that certain is exempted from RTA, which means you cannot seek the information from this institution. This is what you need to remember for the examination. The next topic talks about organ transplantation in India. Now, you need to understand, see, question can be asked about this institution called National Organ and Tissue Transplant Organization. So, a new directive has been issued by the Health Ministry, mandating every case of organ transplantation must include a unique NOTO ID for the donor as well as recipient. Well, this is something that you need to remember. This organization was established under this act, which means this one is a statutory body, important to remember. It functions under the Directorate General of Health Services, which falls under the ministry. So ministry is important, this act is important, and what is the purpose of the act? To improve access to transplantation by promoting organ donation across the country. To regulate the organ donation in our country, this body was established. Divisions of noto. So these are the two divisions. This one is responsible for organ procurement to register and distribution. This addresses the gap between demand and supply of tissues to ensure quality assurance. Status of organ transplantation. These are some numbers. Again, I want you to read, self-explanatory. There's nothing much in this. Then who regulates? Again, this is the act that we have discussed. Again, something you can read by your own. These are the new regulations framed in the year 2023. So there's nothing much to explain. It's self-explanatory. So please read by your own. Now we'll understand what exactly is zero FIR. We have understood what is FIR. What exactly is zero FIR? First, we'll understand what is FIR. Still, we'll repeat what is FIR. It's a written document, which means whenever a crime takes place, whenever, let's say, cognizable or incognizable offense takes place, then a person has to file FIR. This FIR is actually created by the police when they receive information about a cognizable offense. Cognizable offense, again, it refers to a crime where the police are empowered to arrest the accused without a warrant. No warrant is required. Now, though the FIRs are primarily associated with cognizable offences, they may also be filed for non-cognizable offences under certain conditions. For example, under section 155 of the CRPC, the old law, in non-cognizable of cases, police cannot register an FIR unless directed by a magistrate. Can only register FIR once the magistrate declares or gives permission. As per section 154 of CRPC, the registration of an FIR marks the beginning of the only once the FIR is issued, the investigation begins. And as per section 166, any public servant who fails to register an FIR will be punished for 2 years of imprisonment. Which means whenever crime takes place, you go to the police station, you file a written complaint. This is FIR. It is duty bound for the police officer to file the FIR. Then what is zero FIR? What is zero FIR? Now zero FIR, which means it's a type of FIR which means any police station can register regardless of the jurisdiction. For example, as per the original law, if a crime takes place at a particular place, then you need to report in the police station in which that area falls under. But here zero FIR, which means any police station can register no matter what the jurisdiction is. Especially with respect to cognizable offence, it ensures that a person in distress can immediately lodge a complaint. Else, it shouldn't be the case that a police officer is telling you to go to that police station and complain. Which means zero FIR, which means you can lodge a complaint from any police station for the cognizable offense. And the main objective of zero FIR is to allow victims, especially of grave crime like murder or rape, especially women and children, to file a complaint promptly, even if the police station does not have the jurisdiction of the place in which the incident has occurred. This is the main objective of zero FIR. And the process and transfer you can read by your own. This brings us to the last topic of the miscellaneous section, which is the Mission Karma Yogi. It is officially known as National Program for Civil Services Capacity Building. This was launched by the Union Cabinet on 2nd September 2020. Right? This is Mission Karma Yogi. Now, what is the purpose? It is aimed at transforming the India's civil services by enhancing the efficiency. We know that the civil servants, we often hear about the inefficiency that has crept into the system. The purpose of this mission is to transform their efficiency, or transform how? By enhancing their efficiency from effect and effectiveness through competency based training and digital learning. So what is this platform? This platform can be asked in the examination. So we'll also discuss about this platform. The program is designed to benefit 46. Again, this number is not important. So let us try to understand the essence. Now see, if you see the mission Karma Yogi, it actually, we see a shift from rules based system to, let's say, a role based approach. It ensures that the job roles are assigned based on the competency rather than tenure or hierarchy. So far we used to follow the hierarchy, tenure, but now we are actually focusing on the competency, whether an officer is competent enough to handle the case. So this actually includes or incorporates both on-site and off-site learning. It creates actually a mixed training system. So this actually, the purpose is to enhance the efficiency of these civil servants. Now, which are the 6 pillars of mission Karma Yogi? So these are the 6 pillars. One is the policy framework, institutional framework, competency, digital learning, EHRMS, monitoring. So these are the 6 frameworks. So you please remember these 6 frameworks. And also the description of each of these frameworks or pillars is mentioned in the notes. So make sure that you are also going through it. Then talking about the platform. So this one can be asked in the examination. So please read it carefully. So this is a platform of digital learning tool developed under the Ministry of HRD, Ministry of Education. It enables anytime, anywhere learning for civil servants using AI driven models to offer personalized learning experience. So training, so question can be, the IGOT Karma Yogi platform is related to which of the following? So the digital learning AI based models are there in the system platform through which it offers personalized training. So the platform acts as e-learning marketplace, curating content from both global and Indian institutions. And this program is overseen by the Public Human Resource Council, which is chaired by the Prime Minister directly. It includes members like Union Minister, Chief Minister, HR experts, and the international leaders. So again, these are the points that you need to remember for the examination. So the significance being that this Karma Yogi mission, it aims to strengthen the public institutions to instill a competency based, performance oriented work culture and not hierarchy driven. The purpose is to drive technology adoption in governance, to integrate technology in governance, especially the latest technology being AI. So it ensures that there's continuous learning. It's not that the learning stops. It ensures there's continuous learning and also capacity building for civil servants, so that these civil servants are in a position to ensure the governance they offer is effective, efficient, and most importantly, it eases the life of the common people. This is the purpose of Mission Karma Yogi. And this brings us to the end of the topic under the theme miscellaneous. And this also brings us end to the Polity Masterclass program. We have discussed roughly close to 110 topics under various themes. I hope, students, you have enjoyed listening to all the topics under all the themes we have covered. All I can expect from you is to download the notes, ensure that you are revising the topics wherever I emphasize. Please make sure that when you download the copy and the point where I emphasize, please put a star mark so that before the prelims examination you focus on those keywords, so that you revise again and again, so that it instills in your mind and it helps you to recall in the examination. I hope you have forwarded or spread the word to as many people as possible. Again, people who are requiring or who are in need of quality current affairs lecture, please refer them to our channel. Here we are providing this service absolutely free of cost. The purpose is to only help the aspirants, so that the aspirants get good marks in the prelims, help our program, helps the students to clear the prelims examination, which I consider is the toughest level in the UPSC journey, more than mains and interview. So I hope you enjoyed watching all the topics that we have discussed. Thank you so much for watching, and before I call it a wrap, make sure you're liking, you're subscribing and spreading the word to as many people as possible. Thank you once again for watching.